Hello.
Welcome to the second in our 16 webinar series, Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and the LLM program, which Catholic University has cooperated with Jagiellonian University in Krakow, Poland for many years. I will be your moderator. Louise Lydon, the Executive Director of Development and Alumni Relations for the Columbus School of Law of the Catholic University of America, will bring greetings from our law school.
Thank you, Professor Wortham. It's a pleasure to be here with all of you. I want to applaud Professor Wortham's leadership from our end in putting this program together, which she will say was a team effort. And I really want to recognize her efforts to foster and cultivate the relationship with the best law school in Poland at Jagiellonian University. It's an honor to work with someone so knowledgeable about law, but who is also a genuine, friendly people person. She has built on the deep roots established by the founder of the Catholic Jagiellonian relationship, Emeritus Professor Rhett Ludowkowski, who many of you know. Catholic law values this almost 30-year relationship and partnership with Jagiellonian University. The International Business and Trade Summer Law Program, American Law Program, and LLM in America Law now have more than 2,000 US, Polish, and other international alumni, and we welcome everyone here today. The panelists today are superb, and my hope is that these Zoom meetings, we may grow our community, create even stronger shared global experiences that the Catholic U and Jagiellonian programs have fostered. Thank you for being here with us today. We value your participation, and we look forward to seeing you more often. So stay well and don't be a stranger. Back to you, Professor.
Great. So now I'd like to ask Wojciech Bańczyk from the American Law Program, American Law School Coordinator, to give greetings on behalf of Jagiellonian.
Professor Wortham, thank you very much for those nice participants of the series of webinars. It's a great pleasure for us that you all joined us in the online meeting, showing your interest in the contemporary challenges in American and global in varied initiatives coordinated by the Catholic University of America and Jagiellonian University. Many of such initiatives have been developed throughout the cooperation, which lasted for years, actually longer than the lifetime of quite many participants. Given the current difficulties, the traditional way in which the joint programs used to be held is no longer possible. We decided to develop a new initiative that, in the absence of traditional inside meetings, we will have a new way to learn and to meet together. At the same time, we do hope that sooner or later we will meet in person during our programs or alumni events. Thank you very much, and I'm very happy that we all can be here.
Great, thank you. 3.5 hours ago, we had 279 people registered for this event. We're delighted to have so many participants from both sides of the Atlantic and hope these numbers will grow over the remaining 14 webinars. We encourage the alumni on this call to suggest to classmates that they join in the future. For those of you who are new to the Catholic Jagiellonian programs, we welcome you and encourage you to let others know whom you think might be interested in this series. Many people at Catholic and Jagiellonian have played important roles to bring this series to fruition. First, of course, the support of Dean Stephen Payne from Catholic University and Dean Jerzy Pisieliński from its Faculty of Law and Administration at Jagiellonian have been critical. They were with us last week to kick off the series. We also thank Piotr Szwedo, the Jagiellonian Director of the Center for Foreign Law School Cooperation, often referred to by its Polish acronym OXPO, Juliana Kobierzyńska, International Relations Specialist of the Foreign Law School, who has been at OXPO since its founding more than 20 years ago. Special thanks to Lena Helinska, who designed the terrific webinar and OXPO websites. The URL is in the chat. There you can find the dates and topics for the next 4 webinars, which will take place through December, and the bios for the speakers for the winter and spring series that will be offered between January and early June. These webinars are also only possible with hard work from the Catholic University and Catholic Law School Development and Alumni Relations Offices. Louise Lydon is supported by Kate Smith, our Alumni Director, Jean Emery, the Office Manager, and Pasha Madwani from University Development, who provides the tech support needed for registration system and webinars. Thanks also to Catholic University's communication staff, the law school staff, Joe Ferraro, Al Washington, and Jillian Salazzo. Finally, I'll thank our LLM coordinators and LLM graduates, Gaspar Cote and Luke Bartosik. There will be a virtual information session on the LLM on November 4th at 7 p.m. Polish time for anyone who's interested, and that link is in the chat. So now we turn to today's program, a webinar by Catholic University Professor Sarah Duggin on why compliance matters, the increasing significance of the compliance and ethics function in global corporations, with comments by Dr. Michal Rams of PricewaterhouseCoopers in Warsaw. Professor Duggin, if you would go ahead with your screen share, I'll say a few more words about how the webinar will be organized and introduce our speakers. Most of you have probably used Zoom before or a similar video conference platform. I've already mentioned information placed in the chat. You should see a chat button in the tray at the bottom of the screen, or depending on the device, it might be at the top or the side. When you click on chat, you will see that what others have typed in, and there's a bubble at the bottom where you can type in questions that you would like directed to the speaker and to the commenter. In the Zoom version we're using today, you should also see a participants button. When you click on that, you can see the names of who is signed in. If you go to the gallery view button on your screen, likely at the top for most of you, you can screen the screens of those who are signed in. And if they have their camera on, you can see their faces with identifiers in the lower left-hand corner. In addition to the interesting webinar and Q&A that will follow, you can use the participant list, the screens, and the screen names to replicate at least a bit of the networking that you would find in a live event. If the name of your device that appears in the participant list and on the screen is not your name, for example, if it says Leah's iPad, I encourage you to change that identifier to your name for this webinar. To do that, you hover in the upper right-hand corner of the screen until 3 dots appear. You click and you can rename. Unfortunately, the registration software we are using does not recognize some Polish characters. I apologize for the people who have a question mark in their name. To avoid this in the future, please use the English version of letters when you register. We tried to fix it, but it just wasn't possible, so we're sorry about that. Professor Duggin will speak for 20 minutes. She'll be followed by a short comment from Dr. Rams, who also will lead off the question and answer period. As I mentioned, type your questions in the chat as you think of them. After Professor Duggin answers Dr. Rams' questions, then I'll start to pose the questions from the chat. This session is being recorded, and the 60-minute webinar will be posted on CUA's YouTube channel within a few days, and the series website has links to those recordings. At the end of 60 minutes, I will close the formal webinar and the recording will cease. Professor Duggin and Dr. Rams graciously have agreed to stay on for up to another half hour so we can take more questions. So I encourage any of you who would like to stay on for more questions and discussion. In the chat, you will see links to bios for Professor Duggin and Dr. Rams. I will mention only a few highlights, and you can follow the links for more information about their distinguished credentials. Sarah Duggin is a full professor of law at Catholic University, as well as the director of CUA's Compliance, Investigations, and Corporate Responsibility Program. Prior to joining the CUA faculty, she had a rich and varied legal career, including managing the 150-person law staff of the U.S. National Railroad Passenger Corporation, Amtrak, as vice president and general counsel of Amtrak, as chief counsel of the University of Pennsylvania Health System, as general counsel of the world-class hospital, the Children's National Medical Center in Washington, D.C., and as a partner at Williams & Connolly, a noted Washington litigation firm. She teaches and writes in the areas of corporate, compliance, constitutional, and professional responsibility law. Dr. Michal Rams is the white-collar crime team leader and legal counsel at PricewaterhouseCoopers in Warsaw. He is a magister and PhD graduate of Jagiellonian University, concentrating in criminal law and particularly economic criminal law. His experience includes complex criminal proceedings on tax and public procurement matters, advice on potential criminal liability of management board members, and internal investigations in criminal and penal fiscal law. He's an assistant professor at Stefan Wyszyński University in Warsaw and the author of publications in substantive and procedural criminal law, including being co-author of the Walters Kluwer Commentary on the Polish Criminal Code. We are also very grateful to PricewaterhouseCoopers and to the managing partner, who is an alum of our summer program, because PricewaterhouseCoopers has been kind to host a number of US summer program students in internships in their Warsaw office. We're delighted this session brings Professor Duggin and Dr. Rams together, given their broad and deep experience in compliance and corporate investigation. As many of you probably know, Poland in general, and Warsaw and Krakow in particular, are major players in the growing world of business services centers, which provide functions to major corporations. By the end of 2020, at least on pre-COVID numbers, 338,000 people in Poland were to be employed in the 1,500 centers, which have almost 78,000 employees in Krakow and about 64,000 in Warsaw. Banking, financial services, and insurance is the third high sector of this work, and risk and compliance services for US-based and other global companies are processes that employ a significant number of people in Poland. We now turn to Professor Duggin. Please remember to type your questions in the chat, and her remarks will be followed by comments by Dr. Rams and leading off the questions.
Thank you so much, Professor Wortham. I am honored to be here today, and I am absolutely delighted to look on my screen. I have two screens so I can see better, and I'm so delighted to be able to see so many familiar faces and names. What a joy. Thank you so much for including me in this program. It's also been an honor and a joy to work with Dr. Rams, and we've had a few opportunities to speak about comparing what's happening here in the US and in Poland and in Europe. So in my remarks, I'm going to be talking about things from the US perspective, and then in his comments, he'll be bringing us a bit up to date on what's happening in Europe. So just so you know where I'm going today, I want to talk a little bit about corporate criminal liability in the US, because that's so integrally related to what we're doing, and a little bit about the costs of non-compliance, how we got to where we are, what we're doing today, and some possible ideas about what may happen tomorrow as we go forward. So, a big motivating factor anytime we talk about a function, particularly in the corporate world, we want to say, what kind of benefits are we going to get from that function? I can remember as a general counsel really having to say, how do we bring value to the corporation? And that's absolutely critical. But when we talk about compliance, I think the primary motivating factors here are the costs of non-compliance. What happens if we don't, in large global companies, have really robust compliance and ethics functions? Well, we had a wonderful talk from Mark Liebscher last week about the consequences of the Wirecard scandal, and that's certainly one example. But any corporation, any business that's faced with getting caught in a situation of non-compliance or inadequate compliance program in the US faces criminal sanctions, civil sanctions, and civil sanctions can be extremely costly in the United States. Volkswagen, for example, paid $1.45 billion in civil penalties to resolve EPA Clean Air Act violations as a result of the tampering with the emission systems in its cars and how they were registering on testing equipment. They also had to deal with an independent compliance monitor, an independent auditor assigned to look at what they were doing. Another issue for us is potential debarment, being banned from entering into contracts with the US government that can have tremendous financial costs. We also have the False Claims Act in the United States that carries penalties of about 3 times the amount of any service overpaid for by the US government, with an additional $11,000 penalty. That may not sound like much, but think of a healthcare provider, for example. 1 or 2 days in a hospital could have 500, 600, 700 separate services. Every aspirin is going to be charged as a separate service. Multiply that by 3 and add 11,000 per service, and you get up into the stratosphere very, very quickly. We also have significant private civil actions. The False Claims Act can be one of those because they can be initially brought by whistleblowers who get a percentage of any government recovery. We then have lawsuits against corporate officers and directors. And of course, if you're an officer or director, you care a whole lot about that personally. All of these things have impacts on stock price, and they stand to do a great deal of reputational damage, which carries a lot of associated losses, particularly in these days when social media can broadcast anything that happens so quickly and get it to consumers everywhere. So how did we get to where we are today? We begin with the idea that corporations, and of course other businesses, but that corporations can be held liable criminally because compliance, as Michal and I have been talking, really does focus first and foremost on criminal actions. And the original establishment, or probably the landmark case for us, was the New York Central and Hudson River Railroad Company way back in 1909. And that established the principle that in the US, corporations can be held criminally liable under federal law. It reflected an emerging doctrine in the states, and it is shared by most states today. There are 3 elements to corporate criminal liability. 1, an offense committed by the corporation's officers, directors, or agents. 2, that needs to be within the scope of their employment, but that's very, very broadly construed. And it must benefit, at least in part, the corporation. Take, for example, Wells Fargo and the creation of fraudulent accounts that caused such a major scandal just a few years ago. Wells Fargo had an incentive system, and the incentive system essentially paid a lot more for bringing in more accounts. People who wanted to get higher compensation and who wanted to have an opportunity to get promotions tried to bring in more accounts. So in a sense, they were incentivized to do something that violated the law. And even though they were looking for personal gain, they were also benefiting the corporation by bringing more things into the corporation. So that would be an example. Now, despite that 1909 decision, what happened so much was that for the next 70 years, we really had very little in the way of corporate criminal prosecutions. Everyone was pretty much willing to say, oh, if a corporation has a criminal problem, it's that rogue employee or that rogue department. The corporation's really the victim of these unscrupulous employees, the poor corporations. And if you want to take a look at how that really comes forward, we all know about the Delaware effect. I know lots of us talked about it in class. But back in 1963, in a landmark case, the Delaware Supreme Court said, you know, you can't hold directors liable for failing to make sure that their corporations don't engage in criminal liability. There are those rogue employees out there. And I quote, absent cause for suspicion, there's no duty on the part of directors to install and operate a corporate system of espionage, how shocking, to ferret out wrongdoing, which they have no reason to suspect exists. So that established this whole idea that directors really could kind of go about their business for the most part, unless somebody was waving a red flag that there was a problem. Now, that lasted for close to 3 decades after this initial kind of thought that maybe we could hold them liable. We started to see some signs of change in the late 1980s. We had a whole sentencing reform project in the United States that in part recognized that white-collar offenders were being treated much more leniently than other offenders, and that was a cause of social concern. We also saw that there were misaligned incentives in the sense that corporations were rewarding activity that could be non-compliant, and that didn't seem like a good idea. And as prosecutors became much more interested in going after corporate offenders, they perceived a need to leverage resources because it takes so much to unearth these complex financial cases, as I know many of you know. In the 1990s, however, a whole new era came about, and I think the immediate stimulus was the organizational sentencing guidelines, because in 1991, our US Sentencing Commission that was created in 1984 said, look, if a corporation gets charged, gets convicted, or settles a case through a plea agreement, the judge needs to look at 7 factors that have to do with how any kind of compliance function is operating. But if the judge determines that that was an effective program, then there will be mitigation of sentencing. Following on that, we had our Department of Justice create policies talking about how we're going to go about deciding whether or not to prosecute corporations and other business entities, and not-for-profits as well, but the focus was on business corporations. So we started to get first memoranda from the officials in charge of our criminal division of the Department of Justice, and then actual policies in the United States Attorney's manuals. Then in 1996, in a case in Delaware, the Delaware Court of Chancery, which is the most expert court that deals with corporate cases in the country, because they deal with all of Delaware corporate cases, handed down a decision that really had to do with just settling a shareholder's action. But in the course of that, the chancellor said, you know, I don't think that 1963 decision is binding on me today, because I think that in the 33 years since the Delaware Supreme Court decided that case, things have changed a lot. And in my view, and I quote here, a director's obligation includes a duty to attempt in good faith to assure that corporate information and reporting system, which the board considers adequate, exists, and that failure to do so under some circumstances may render a director liable for losses caused by noncompliance with applicable legal standards. And what the court came up with in that case is the standard still applied today: sustained and systemic failure. Now, that doesn't sound terrible, but it does mean that there's a great deal of potential liability if directors fail to put in place a compliance program, or if one's in place, they fail to pay attention to it. Now, this caused a lot of wailing and gnashing of teeth in corporate boardrooms around the nation, but there were many firms, law firms and consulting firms and accounting firms were quick to react and offer help in providing compliance programs and helping companies develop them. So we went forward for a while thinking we were doing better, and then we had Enron in 2001. Not only Enron, but WorldCom, Tyco, and other major corporate scandals. Those in turn led to what we all know as the Sarbanes-Oxley Act of 2002, and a new focus on us as lawyers and accountants and other gatekeepers. It led to a lot of new rules. And as many of you know, our Securities and Exchange Commission, for example, takes a very broad view of who is, quote, practicing before the SEC. So this net really extends much broader than the United States itself. We also had the creation of the Department of Justice Corporate Crime Task Force that led to many new corporate investigations and prosecutions. We had more guidance coming out regularly, DOJ officials speaking at corporate gatherings and trying to get the word out that the government was serious about compliance and that what was happening so far wasn't working. So, and as we went further in this century, we've had the introduction of whole new tools to ensure compliance. One of the most difficult, I think, for corporate folks is this idea of imposing a compliance monitor. And we have now about 20 corporate compliance monitors at work as of April 2020. Many of them are under Foreign Corrupt Practices Act that has to do with US corporations, or other corporations associated with US corporations essentially paying bribes to foreign government officials, which can be at a very low level or very high level, and others with what are called MIMF, or market integrity and major frauds. Just a few recent examples, we have corporate monitors, compliance monitors, outside monitors, with the company paying all costs in place at Panasonic Avionics, Walmart, Deutsche Bank, and a number of other major corporations. So we also had greatly increased costly shareholder actions. And I know that that's not quite as common in Poland and in Europe, but in the United States, it is a matter of significant interest to directors because the costs are very high, number one, and these filings go up and down. But in 2018, the last time I could find statistics, they had increased about 225% over the preceding 10-year average. So some notable settlements would include Wells Fargo in 2019, $320 million in this civil damages case. News Corp, parent to the Wall Street Journal, in 2013, $139 million. And you can see some of the others there. We're talking about serious money. We've also had a spike since 2017 in securities class actions, many of which target non-US companies, especially in merger contexts. So a lot's going on with civil penalties and civil actions, and I've also already mentioned the False Claims Act. All of this has impacts on individual officers and directors. Now, back in 2015, during the Obama administration, Sally Yates, who was in charge of the criminal division at the Department of Justice, talked about a renewed focus on individuals. That hasn't really made a major difference, but it certainly has an interim effect. We've also had individual officers, directors are very much affected by shareholder derivative actions because most of them have to do with breach of fiduciary obligations. So this is a very serious matter. So where are we today? Well, it's very important to realize that the compliance and ethics functions have become an integral part of corporate governance in the US for all reputable companies, and even some at the fringes. The CEOs, you can look at it, the Economist magazine surveys of good company ideas, and in at least one of those surveys, the CEO said, well, if we're talking about corporate responsibility, as there's a lot of talk about that these days, and even some action, legal compliance is probably the single most important component. We also have had, since the early days, a really carving out of different specialized functions that I know a number of you are probably involved with. When I was a general counsel, I had to manage compliance and I had to manage risk management. That, in many corporations, that's no longer true. We have the rise of the chief ethics and compliance officer, and note from the early days it was compliance. Now we've wised up that it's ethics and compliance. And we also have a corporate risk manager. These three people together are fulfilling really invaluable roles. We now have the chief ethics and compliance officers rising up in many corporations to the C-suite and engaging with the board in the same kinds of ways that in public companies, chief financial officers meet and general counsels meet with board members or the outside directors without the presence of the inside director. So that's a best practice now. We've also seen shifts in the US law school curricula. For example, in our own law school, we have the Compliance Investigation and Corporate Responsibility program. That's a phenomenon that's sweeping the country. I'm proud to say that we were on the first floor of that, and in part with Professor Wortham's encouragement and help, and talk about what so many people in Poland are doing and how important this is becoming. But we are seeing a whole change in legal training as these options become available. It's still not a huge part, but it's an increasingly important part. So I thought I'd conclude with a view of where are we today and where are we likely to go. And these are just a few of my own conclusions. I think prosecutions are going to continue. During the Trump administration, and even at the end of the Obama administration, federal corporate prosecutions have declined, and individual prosecutions as well, but they're going to increase. If we have a new administration in the United States. I think a Democratic administration is going to be a lot harder on corporate crime. And even if it's not, one of the reasons these prosecutions have declined is less policy than the number of vacancies in the Department of Justice. That should be changing. I do think that compliance systems are going to be key to resolving government investigations. Prosecution and public settlement figures do not really reflect the reality, because we have a lot of government investigations, and just in the decision whether or not the government will expand an investigation, whether it will prosecute, whether it will seek a resolution, criminally and in our civil enforcement actions, such as the Securities and Exchange Commission, the Environmental Protection Agency, a number of other federal agencies, those are really critical. And in our most recent guidance in the Department of Justice's April 2020 evaluation of corporate compliance programs guidance, they're asking 3 key questions that really put together the factors that have been talked about over the years, looking at design, application, and outcomes. We see not just a process here, but a real outcomes application. And corporate watchdogs and shareholder groups know what's going on. They're going to continue to be watching. Director and officer liability is going to, I think, continue to remain low. It's surprisingly low in light of all the hoopla about it, all of the publicity, but defense costs are high. And for corporate directors, there's a fear factor, and officers have a lot more reason to fear. They face significantly higher risks. We have costly indemnification insurance coverage disputes. That's true in any country, I'm sure, at any time. It costs a lot to litigate these cases and to try to get coverage. Reputational risks, as I mentioned earlier, to businesses have a real chance to influence market share and a lot of problems for businesses. And as I mentioned, the thought that they would have to be subjected personally and financially to prosecution, investigations, or to other serious civil discovery efforts really has an impact on corporate directors. Finally, I'm going to end with an aspiration. Compliance and ethics functions are really important. And as many of you know, they're really important to me because I see this as a way of really resetting and continuing to reset our moral compass. And I think that if we continue expanding these functions, they offer some real promise to help address human rights abuses in global supply chains, environmental harm, and other serious moral and ethical issues. With that, I will turn this over to my colleague, Dr. Michal Bruns. Thank you.
Thank you very much. First of all, thank you very much for including me to this very interesting program. And right now I will present you some comments regarding Polish and the EU approach to this problem, this compliance problem. Due to the fact that I had only 4 minutes and I like to talk, thank you, Professor Duggin, for giving me a bit more time for my comments and questions. So first of all, I would like to mention that in the current legal situation, both in Poland and in Europe, the issue of compliance is most often associated with criminal law, including in particular white-collar crimes, as well as fiscal violations. This is probably the reason why, as a person dealing with the issue of white-collar crimes, I'm also involved in design and implementation of such systems in practice within my organization. In order to explain the linkage of compliance with criminal law, some preliminary remarks should be made, which will allow us to show some differences between the US model and the Polish model. So first of all, it should be noted that in Poland, primarily managers and persons responsible for running the company's economic and financial affairs are held responsible for committing white-collar crimes, not companies. First of all, managers and higher officers. Importantly, this also happens when it can be assumed that the company has obtained direct or even indirect financial benefit from committing crime. So this is very important. This is due to the fact that, as for now, there are no effective regulations regarding the criminal liability of the company, collective entities liability, corporate criminal liability, in fact, the beneficiary for such a crime. What is more, even when the perpetrator's action lead to a specific depletion through reduction of tax, she, and not the company is obliged to restitution. So this is the law right now. The same obligation relates to damage caused by a crime by a particular perpetrator who is an individual and who will be found as guilty. Such restitution also takes place through criminal proceedings based on the available mechanism which comes from the Code of Criminal Procedure, not from the civil action against a particular person. There is no need to initiate a separate, for example, civil or economic proceedings against such a person or against a company. You don't need to initiate a civil action against them. As a result, in Poland, generally, only managers or higher employees, officers are liable for white-collar crimes at this time, at the moment. It all started to change about 2 years ago when the draft of the bill on criminal liability of collective entities for acts prohibited under penalty appeared in our system. And what is very important during this webinar, I have to say that in the justification of this bill, attention was drawn to the fact that it sometimes happens that the natural person is only the executor. Individual is only an executor, but after all, the company is the entity that benefits from a crime. So this is what has been already told by you. Sometimes the company takes benefits from the crime which was committed by a particular individual. This happens, for example, in the case of economic corruption, tax crimes, especially fraud, etc. Therefore, it has been established that in the event of suspicion that a crime was committed, it will be possible to initiate proceedings against the company and impose a fine on it, not on individual. What is very important, the individual hasn't been found guilty even. He can be only suspected of committing a crime, and it will be enough to initiate penal fiscal case against a particular company which operates with him, because he even hasn't been the employee of this company. Such proceedings will be concluded in accordance with the provisions of the Code of Criminal Procedure. So it will be some kind of criminal responsibility, penal responsibility of the company, and the premise determining the company's liability would be, apart from the awareness of its bodies, the lack of due diligence. So this is the lack of due diligence as the main reason of initiating such a proceedings against the particular company, once again. This lack of due diligence is nothing else than the lack of compliance mechanism that would be ensure legal compliance and transparency of activities within the organization. So similar regulations are now also to appear in the area of taxes, where taxpayers will be required to publish a statement on how they approach the process related to tax settlements process and ensuring their compliance with the law. Finally, also within the EU, a directive mandating in the introduction of whistleblowing system within the companies has appeared in recent time. Regardless of the fact that both drafts have not yet entered into force, their content has changed the approach to the subject of compliance in Poland. And for some time now, more and more organizations, although mostly large international organizations, have been striving to build such a system and establish an independent compliance officer function in the company. Although there are no written rules on how to implement such a systems, such a system in a company. Currently, practice has developed the following key points. I would like to describe some key points of this compliance system. So first of all, you have to define the process generating the most significant risk for the company in accordance with so-called risk-based approach. The second one, you have to correct map of the world of compliance by specifying legal acts, internal regulations, regulatory guidelines, and industry standards applicable to a given company, taking into account the risk-based approach. You have to introduce the risk assessment system. So the correct risk assessment system based on expert knowledge and the best market standards. You have to introduce appropriate way of designing the compliance system by posing a dispersed, centralized or hybrid model adequate for given organization. You have to introduce, this is very important, especially in Poland, the compliance risk monitoring and reporting, because it is necessary to monitor these compliance systems in the future, monitoring and effectiveness of the implemented control mechanism and providing competent authorities with information on the compliance status. So by introducing effectively functioning solutions, you have to define the rights and obligations under the compliance system, which are owned by the compliance officer. You have to implement 3 lines of defense. It means, in fact, that the compliance officer should be so-called independent in the compliance. So creation of the modern compliance model under which this unit becomes a business advisor, and the benefits that exist for the organization today, in my opinion, is first of all, the limitation of risk of financial penalties, the protection of company's image. So this is this kind of social responsibility, which was already mentioned by you. Reduction of the risk of losing licenses and permits, reduction of costs of course proceedings. This is also very important. Implementation of the compliance by design principle, which is something totally new for the companies in Poland, and ability to react quickly to risk. This is what we need at the moment in the companies. So this is my comment, and this is how it looks in Poland, this compliance mechanism. I have
Dr. Rams, could you, it'd be good if you could sit back a little bit, because we're not seeing your mouth a lot of the time, and it's a little easier. So I think if you sit back a little bit or move your computer,
okay.
Yeah, it's much, I realize it's easier to hear when we see you.
Yeah.
Great.
Okay. So I have one question to you, because we have been already told by you that there must be a crime committed by some officer. And my question is whether the fact of committing such an offense has to be found by a court in a verdict against this individual.
I think you're talking to me. So I guess a crime, no. To hold a corporate entity liable, yes, you're going to have some kind of. You wouldn't have to show that, you wouldn't have to get the verdict against the individual person, but you would have to get a verdict against the corporation that a crime had been committed on behalf of the corporation. And it wouldn't have to be an officer. It could be an officer or another employee or an agent.
Okay, but do you have some examples that the proceedings against the members of the management board, the proceedings against the officers are conducted jointly with the proceedings against the company?
No, I think that's one of the big differences. American directors, or directors of American companies, I should say, they may not be Americans, are rarely held criminally liable. That would be a very rare event. It's certainly not at the larger level. That happens, but it usually happens when someone's also an officer. For example, Enron, Ken Lay, who was chairman, and Jeff Skilling, who was the CEO, and then Lay became the CEO again, but they had officer positions. But if you're simply on a management board, if you are a member of the board, it would be very unlikely that you would ever be held criminally liable. However, it has become more and more likely that you may be caught up in a corporate criminal investigation. And the burden on people who are caught up in investigations, whether it's an internal investigation or whether it's far worse, if it's a government investigation, huge amounts in counsel fees, the cost of the time that it takes to deal with that, and general unpleasantness and worry is a huge kinds of cost. But it's the officers who are most likely to have individual criminal proceedings against them.
Okay, so this will be my last question. What are the penalties in such proceedings concerning the criminal liability of companies? And could you describe us the premises for these penalties and for the height of these penalties?
A criminal conviction would be the principal way for a criminal penalty, but most of these cases are going to settle. They settle in a couple of ways. In the federal government, we usually have, with the Department of Justice, 3 common kinds of mechanisms. One would be what's called a deferred prosecution agreement. And that's a settlement between the company and the government, could be an individual, but in this case, companies. And in that case, criminal charges are actually filed with a court, but they're not proceeded upon.
Okay.
So they are public. Can't get that in any way other than public. That's called a DPA, or deferred prosecution. If the company abides by the agreed upon terms, then the charges will never proceed. But until they do, they will be kept on record. Then we have a non-prosecution agreement, or an NPA. And what that says, that essentially says, here are the charges that we would bring against you. We will file those charges if you don't abide by this agreement. So it's a little bit different. It does not need to be made public. The policy of the Department of Justice is usually to keep those going. We also have other kinds of agreements where, when the government's making a decision whether or not to prosecute, they may decline to prosecute, but there's going to be a lot going on along the way in an effort to show that the company has a great deal. The specific penalties would be fines, penalties, probation, and the requirement of a corporate monitor at the cost of the company to oversee one or more lines of business.
Does your system has some kind of provide some kind of preventive measures against the companies during such proceeding?
Yes. That's the primary goal. The most vulnerable time, I think, having practiced in this area a while back, but still I was connected with it the first 10 years or so when I was teaching. And what I found is that the most vulnerable time is when a problem has been discovered, a big problem, but the government's gotten to the point where you really get a great advantage if you actually disclose before the government actually finds out. The problem is that you don't really want to just say, oh, we've got a problem, let's go disclose. What you really want to do is say, we've got a problem, let's show that we're a good company and we're taking steps to fix it. So when we go to the government, we'll say, we had this problem and look, already we had systems in place and we've ramped those up, so that you come to the company looking like the good company. But, that's the really vulnerable time when you're trying to make that calculus. Do we have 2 weeks to deal with this, or do we got to go rushing in? Or is it maybe low enough that we don't really have to disclose it? Those are the toughest counsel decisions working with senior management.
So much to both of you. We have about 10 more minutes in the recorded part, but I'll remind you that once we turn off the recording, we have another half hour. So we will have time to get to more questions. I'm going to take, so now is a good time for people who have questions they've been thinking about to put those in the chat. I'm going to start with the first one I see from Eric Hirschhorn, who actually also is my husband. So, but I can say that he was an undersecretary at the Commerce Department who was in charge of the export control program. So that's what he's saying in his experience as a regulator. And I think you would definitely agree with Sarah that the first thing you want to do is fix your compliance program and come in and say, see, we fixed the problem. He says, in my experience as a regulator and as a lawyer representing defendants, I've found that the potential for individual liability, especially criminal liability, is more of a deterrent than concern about corporate liability, which of course is paid by the shareholders rather than the wrongdoers. Can you comment on that? So first, Sarah, and then Dr. Michal, I'd like to hear both of you comment on this question. So Sarah?
Oh, I think that's so right, Mr. Hirschhorn. I think that if I risk the chance of going to jail, I'm going to be so honest. Absolutely. But I think that even though, but the reality is that for directors, that is extremely low likelihood. But what I found, and this was the subject of an American Bar Association program a year ago at the business meeting in Vancouver, we had a panel based solely on this whole idea of how are companies dealing with paying legal fees for officers and directors, which is of course of concern to us as lawyers. But just several years back, there was some litigation involving KPMG, and there was a settlement where the government tried to, it wasn't quite a settlement, but on the way to a settlement where one of the conditions was going to be that the company would not fund legal fees for individual officers or employees. And I don't think there were directors involved, but to some people like that. And there were some other agreements about no joint defense agreements, which are really important in American law in the defense of major kinds of investigations and possibly criminal proceedings. So that had another level of interim effect, because not only were people worried about the possibility of going to jail or paying heavy fines and penalties, but the individual cost of these complex cases can easily run into millions and millions of dollars. I still remember that the retainer that Jeff Skilling paid his lawyers was something in the neighborhood of $23 million just as a retainer before the Enron investigation. Now, most things aren't Enron, but still. So yes, I totally agree with you. And I think it's because of the fear factor, even if it's very, very remote, that one would go to jail. If you're an officer, it's less remote, but still, I think that fear factor is critically important.
Yeah, I fully agree with you, but we have totally different situation in Poland. So first of all, we have only criminal cases against particular individuals. And what is very important right now that these criminal proceedings are used by the government as the mechanism of pressure, especially in tax criminal cases, when you have board members who are responsible for financial matters, and you have at the same time tax audit initiated, for example. So the government wants to have a deal with these board members, and when they are going to initiate penal fiscal case against particular individuals, this is the mechanism of pressure. This is some kind of mailbox against them. Yeah? So even if there is a fear, even if they don't commit a crime which is related to this particular case, sometimes they are faced with potential charges because this is needed by government. The government needs it to conclude an agreement with the particular company. We have a lot of similar cases at the moment, especially in tax sphere. So this is the common practice when a penal fiscal case is initiated at the same time as a tax audit. And you have a potential perpetrators which are faced with some charges, criminal charges. And this is a very strange situation because these proceedings are discontinued in the future, but they are initiated by the government.
There was a comment in chat from Piotr Simoninski, a very good point, asking if Dr. Rams might have had an abstract or a sort of a recap of his points, because it is, I know, always helpful, especially when people are native speakers of different languages, to visualize. I'm not sure we have a way to do that you know, going forward, but that's a point for us to think in the future. And I do appreciate suggestions, because we are adapting as we go along. And I think next time we will suggest that the commenter might also have a slide of key points, because I agree that that's really helpful. I was fortunate to see Dr. Ram's comments in writing, so that was helpful to me as well. So we're ready for questions. I think we have time for one or two questions from the audience before we move on. I have one I'll ask, since I don't see another one yet, so be thinking of your questions here. Richard Susskind, who of course is very famous to many people in commenting about the future of law practice. I know his books are translated into Polish, and he came and spoke to the legal advisors. And he stresses a lot that law schools maybe haven't done a very good job in helping students to think about preventive law. We get very focused on litigation. People, you know, right away are reading cases and thinking about, you know, litigation. But one of his expressions is, it's better to have a fence at the top of a mountain than an ambulance at the bottom. So I'm going to ask again, and this will be the last before we stop the recording, but please do, our people in our audience. And for example, if there were things that Dr. Rams said that you felt you missed, that's a perfectly fine question too, to go back to something. But our last question before we turn off the recording will be both first to Professor Duggin, then to Dr. Rams. How well do you think law schools are preparing people to think about compliance and preventive law? Do you think there are ways that we train students that perhaps almost direct them away from that point of view? Professor Duggin?
That's a wonderful question. And I'm all in favor of fences rather than ambulances. I think that partly because when we come into law school, the whole idea you're going to go to court, you're going to be talking about things, you're going to be fighting for your clients is such an attractive idea. But the reality is that most legal work is going to be about giving advice, and the standards are really quite different. And I find that when I teach corporations in the US and first bring that up to my students, it's really hard for them. It's really hard for them also to think about what are the realities that business people are facing. To business people, it's not just about paying by the hour for lawyers' time. It's also about the resources and the management resources that must be devoted to particular problems. So the whole idea of training all of us more to think about preventive law is critically important. And I think it's really been incentivized by the government's approach beginning in 1991 with looking at whether or not there are effective compliance programs in place. I'd also argue that it's not simply, certainly compliance is about criminal law in an awful lot of ways, but there are so many other issues, because when something goes wrong with an emission system, when we find out that there's child labor in a supply chain, there's a huge market reaction and a huge reaction from consumers that's magnified by social media and instantaneous communication. So I think that fence building has a huge amount of benefit. And I think as law schools, we need to continue to expand our emphasis in that direction.
Dr. Rams?
Yeah, I fully agree with Professor Duggin, because I think that the preventive mechanism and implementing preventive mechanism in the companies, this is the very new and very important element of law. And in my opinion, you don't have enough knowledge about it during your university education in Poland, but everything has changed in recent time. So I think year by year, there will be more knowledge about this particular part of law. which is developed, well developed in Poland in recent time. And, you know, this is very difficult to predict what the verdict will be in the court. So this is the most important question that every litigator should know. You don't know what the verdict will be in the court. So that's why you are trying to build and to implement some preventive mechanism to discuss with your client and even with the prosecutor about the potential solutions and not go to the court. But it needs time to develop this idea.
Great. We're now at 60 minutes. So if some of you have only planned for an hour and need to go, we are very glad you are with us. I remind you that we have an information session on the LM program on November 4th. We'll put that link in the chat. But I encourage people to stay on with us for the additional half hour. We do have some additional questions. So we will now start to do those. I think Kate Smith's going to turn off the recording button. And so we have a question.